In the history of litigation, there are many interesting yet bizarre legal cases. Hello, I'm Prachi Pratap, and today we will discuss some such interesting cases. The first case we'll discuss today is Mary Buck versus Walmart. Mary Buck sued Walmart over 2 cents. She was shopping at Walmart and she purchased a product which was listed for 98 cents. Although at the counter the product was scanned for $1, Buck pointed out the cashier's mistake and got her refund. When Mary went to the store later in the week and purchased the same product, the same thing happened again. She was furious and realized that the company was fooling their customers. Thus, she decided to file a case against them and $100 and compensation for $80 for the case charges. The big giant Walmart was sued for its carelessness with the consumers. Another interesting case is Benjamin Carruthers versus Red Bull North America. A class action lawsuit was brought against Red Bull for not giving wings. The commercial of Red Bull clearly claims to give wings to a person. It can be interpreted in such a way that it gives great energy to a person, but Benjamin did not feel either way after drinking the beverage. Benjamin filed a case against Red Bull stating that the drink did not give him wings. Case had its final result in the year 2014 and Red Bull agreed to pay the man $13 million as compensation. The company did not want a lot of hassle, so they agreed to a settlement, yet they claim that they have never promoted false or deceptive advertising. In this case, the court ruled in favor of Benjamin and plaintiffs and thus ordered Red Bull a class settlement for all victims. It agreed to pay a total of $13 million as compensation to the customers who felt cheated by drinking its energy drink in the last decade. The next case that we are going to discuss is about litigation related to weather. Sue the weatherman. In Israel, a woman sued Channel 2 along with weather forecaster Danny Rowe. The weatherman wrongly predicted a nice day and yet it rained. The woman ended up getting caught in the rain, causing her to catch the flu, miss a week of work and purchase medication. She sued for $1,000, claiming that the incident caused her stress and she won the court case. It should be noted that there were papers written on possible legal liability of wrong weather forecast. That has happened a lot over the years in different continents. The next case we'll discuss is Georgia versus Randolph. Can police search premises jointly occupied when one person agrees and the other refuses? Police were called to home for a domestic dispute. The defendant's wife told the police officers that defendant was a cocaine user and that there was evidence of such in the house. When asked for permission to search the house, the defendant refused. His wife, however, readily gave consent to search and led an officer to defendant's bedroom where a section of a drinking straw with a powdery residue was found. Further evidence of drug use was seized after obtaining a search warrant. The defendant was indicted for possession of cocaine. The court held that since the wife had no recognized authority in law or social practice to prevail over her husband, her disputed invitation without more gave police no better claim to reasonableness in entering than they would have had in the absence of any consent at all. The Supreme Court found in favor of Scott Randolph in 2006, ruling, thus a disputed invitation without more gives an officer no better claim to reasonableness in entering than the officer would have had absent any consent. The court noted that disputed permission was no match for the central value of the Fourth Amendment of the American Constitution, and the state's other countervailing claims did not add up to outweigh it. In Fernandez versus California, the Supreme Court held that when the resident who objects to the search of the dwelling is removed for objectively reasonable purpose, such as lawful arrest, the remaining resident may validly consent to search. In Klein, Birdwell versus National Railroad Corp, the trespassers sued the property owners in 2002. Two teenagers trespassed property owned by Amtrak and Norfolk Southern Corp. and climbed on top of a boxcar, that is also known as a train bogie, in hopes of getting a view of the city. An uninsulated wire suspended above the train jolted Klein with 12,500 volts of electricity, causing severe burns over 75% of his body. Birdwell received burns over 12% of his body when he ran to assist his friend whose clothes were on fire. It's hard to believe that anyone could win a lawsuit for being injured while trespassing on someone else's property, but that's exactly what happened. In October 2006 trial, a jury said that although they were trespassing, the 17-year-old boys bore no responsibility for the accident. Instead, the blame fell entirely on Amtrak and Norfolk Southern for failing to post signs of warning of the danger from the electrified wires that power locomotives. For medical costs, pain and suffering, and loss of life pleasures, the teens received a combined compensation of $24.2 million. Now to a recent case, Ashna Roy versus Yogesh, Deveshwar and others. The infamous haircut case. In 2018, model Ashna Roy visited a salon at ITC Moria in Delhi a week before an interview. So she asked for a specific hairstyle as she was a hair products model. However, she alleged that the hairdresser did not abide by her instructions and chopped off her entire hair, leaving only 4 inches from the top and barely touching her shoulders. She complained about this to the management of the salon, who in turn offered her a free hair treatment, which she claimed caused permanent damages due to excess ammonia, which resulted in bald patches on her scalp. She was a model for hair products because of her long hair and had done modeling for big hair care product brands. But due to the haircutting against her instructions, she lost her expected assignments and suffered a huge loss, which completely changed her lifestyle and shattered her dreams to be a top model. She was also working as a senior management professional and earning a decent income. However, she underwent severe mental breakdown and trauma due to negligence in cutting her hair and could not concentrate on her job, and finally she lost her job. The NCDRC allowed the complaint partly and were of the view that it would meet the end of justice in case the complainant is granted compensation of 2 crore rupees. Hence, the hotel was ordered to pay a compensation of 2 crore to Ashna Roy.